The statute has really one of the only available defenses other than acquiring actual knowledge like we discussed in the attorney representation section, is the bona fide error defense. The bona fide error defense it's very simple, and it's basically providing the debt collector, if they can prove by the preponderance of the evidence that they've established policies and procedures to prevent violations from occurring, and the error occurred unintentional despite these particular procedures. Prior to 2010, the bona fide error defense was pretty broad. It covered mistakes of questions of fact, clerical mistakes, and questions of law. In fact, prior to 2010, lawyers that were sued for maybe they misinterpreted the statute of limitations, they filed a lawsuit, could prevail on the bona fide error defense, relying on, well, I thought that Delaware law applied instead of Georgia law. We've won some cases like that before. In a case that came out in the United States Supreme Court called German, the U.S. Supreme Court stripped out the questions of law, so the case has really been reduced, or the bona fide error defense has really been reduced to mistakes as questions of fact. It's still effective. It has not been completely stripped because a lot of the times the mistakes that are handled by debt collectors in these realms are really clerical mistakes or errors in factual issues. Particularly like, for example, where a debt collector receives information about attorney representation. The policy and procedure is to code the computer system in a certain way to stop all collection calls, to code it in a way saying we're represented by counsel or cease and desist. Someone dropped the ball, someone didn't handle the mail, and therefore you go forward in the defense. You're being sued because you made subsequent communications. Then you rely on the bona fide error defense. And if you can provide evidence that a policy and procedure existed and that's enforced, it's trained, everybody knew about it, and it was reasonably adapted to avoid the error from happening, and you just had an unintentional error, just a mistake. If you can provide that and prove that by the preponderance of the evidence, the statute provides that you will not be liable under the statute. It is a very good defense in certain circumstances, but there's two critically areas that you need to protect against. Number one is you have to have policies and procedures, and they have to be effective. You have to have written policies and procedures down that documents what you're attending to prevent, what course of action are you taking to prevent that, are they being trained to the collectors, are they actually in practice working, have you been sued? And there's actually cases that will analyze, have you ever been complained of, have you had similar violations of this sort? The more violations that you have, or the more allegations that there's a problem in a particular thing, erodes your bona fide error defense. So if you have repeated allegations that you're not ceasing communications when you're being told to stop, you're losing your bona fide error defense the more those allegations go forward because it's not being effective. Particularly as we talked about with the CFPB. The CFPB is requiring that in their audits of collection and debt collectors that handle these types of cases to maintain policies and procedures. And when they do an audit, they're going to look at your policies and procedures, your management structure, who's supervising, who's responsible for what. They're looking for accountability. As a trial lawyer, I need to have these policy procedures in writing. It does not do any good to have a compliance officer, the training officer, the operations manager, or the president of the company come in without a policy and procedure and testify in front of a jury and say, well, that's just the way we do it. We don't have anything in writing. That's not very effective, and it's not very persuasive to a jury. My preference is, and it's prevailed in numerous times, is when a jury has the ability to take the piece of paper back into the jury room with them, and they say, yes, here's the policy and procedure right here. Policy number 5 says they this, they do that, they didn't do it, but they actually have something to take back with them into the jury room and say, yes, this is physically what they have to show this. Immensely more important. Juries are listening to a trial during the course. They're not going to remember the testimony of your corporate representative as to what you actually do. If you have a piece of paper the document of the policy and procedure that specifically lays out what you do in those circumstances. The jury's going to be able to take that back as Defendant's Exhibit 1 and say, yes, they have this. Now, was the act unintentional? And if they prove, yes, it was an innocent mistake, but like that, perfect. You got to have the second phase. You got to have qualified, competent, articulate people that are going to be able to testify as to the policy and procedure. Your operations manager, your compliance officer, the president of the company have to be intricately involved in how this process works. And also your collectors need to be trained to process this. It needs to be actually work in progress, not a policy that's collecting dust in the training floor. It needs to be work in progress. So make sure you have a written policy and procedure. Have compliance counsel that are FDCPA trained or at least experienced. Write your policies and procedures and constantly have them updated. Keep a log as to making them better and better as a time period. Not only is the CFPB going to be reviewing those to make sure that you're compliant, it's going to reduce your risk of loss in the first place if you're compliant with the issues. And if you get sued because you had a collector that made a mistake, at least your defense counsel will have a fighting chance to bring forth the bona fide error defense confidently to prevail, or if anything, present that possibility to opposing counsel. Say, well, we have a great bona fide error defense. Here's a policy who's going to testify. You may be able to secure a reasonable settlement early on in the case, or under the threat that you're going to prevail at trial anyway.